Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for September 27th, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
Yeah, Judge, middle page 10. Annex. May we have Alfredo Garza?
Garza.
Yes, sir.
Was it me? Garza.
Mr. Garza?
Yes,
Mr.
ma'am.
Garza, is that okay? All righty.
In cause number 2022 0D01666, State of Texas versus Alfredo Garza. Announcement of council, please.
Samantha Rock on behalf of the state. State's ready, Your Honor.
If you would unmute, Mr. Islas.
I'm sorry, Your Honor. Luis Islas appearing with Mr. Garza on my motion to withdraw as his attorney.
Okay. And so I do have the motion to withdraw scheduled today. We actually have a 2801 hearing on Thursday. So, well, may need to look at that. But in any event, Mr. Garza, are you aware of your attorney's motion to withdraw?
Yes, ma'am.
Okay, Mr. Islas, you may proceed.
Your Honor, on July 21st, 2022, I wrote Mr. Garza a 2-page letter. He received it and responded to me. The postmark on his letter is dated July 29th, 2022. And it's Luis, you are fired, and have told you in my last letter not to file anything on my behalf. I think the break in our communication is irreconcilable. And because of his direction, I did not file anything in his behalf. And in my letter, I believe I mentioned that I was going to file a motion for a competency examination, which I don't think you appreciated. But I would ask the court to permit me to withdraw. He has told me in his correspondence on various occasions that he and his family were going to hire someone to substitute. As of today, I have not heard anything from either he or his family that they have hired someone, and I have not heard from any other attorney. So that's all I have, Your Honor.
Okay. I'm not seeing, did you mention something regarding a competency examination? Was that filed? Was that concern present here today?
It was not filed. I respected his order to me not to file anything on his behalf, Your Honor.
Although you felt that you had a question regarding his competency? What I'm trying to ascertain is if you have and have continued to have a concern regarding Mr. Garza's competency.
I think it would make sense for, I mean, if you don't let me out of the case, that's the first thing I'm going to do. You do let me out of the case, my suggestion to whoever you may appoint or whoever substitutes for me would be to file that. That's the best I can answer you.
Thank you, Mr. Islas. Mr. Garza, I just need to know something. Have you hired an attorney to represent you?
No, ma'am, I already sent a few letters to, because I just got the addresses to the attorneys. So I just sent a few letters, explaining to them, what I needed done and, if they could come see me. One, attorney said that he couldn't come unless Mr. Isla gave him permission. That was Carlos. I
No,
think.
I need you to stop right there. I just needed to know if you had hired an attorney since
Oh, ma'am.
I'm, okay. And you were court appointed, he's indigent, no reason, he's been in custody all this time, right? So, I'm gonna go ahead and grant your motion to withdraw, Mr. Islas. Ms. Hernandez, let's go ahead and appoint the Public Defender's Office. I know we have at least 2 representatives here from the Public Defender's Office. If time permits, Mr. Garza, we will stay on. So I've allowed Mr. Islas. Did you send him a letter saying that you didn't want him to represent you?
Yes, ma'am.
Okay, so the court is going to, again, grant the motion to withdraw and appoint the Public Defender's Office at this time. There are a few deadlines and we are scheduled for trial in March of 2023. So that is ample time, and I will work with your new attorney on any requests they may have regarding scheduling.
Yes, ma'am.
So if we can get that over, as I mentioned, if I have time permitting on this scheduled Zoom hearing, I will, once we're done with our other hearings, ask the Public Defender's Office to at least make contact with you here through the Zoom when we're not here, where it's just you all in a breakout room, so then they can further contact you regarding your case. We are not set, well, we are set on Thursday, so there's a little bit of time to address some things, but for at the very least, we'll look at extending that 2801 deadline.
Yes,
Okay.
ma'am.
Thank you, Mr. Garza. Mr. Islas, thank you for your time. Please submit your voucher, okay?
Yes, Your Honor, may I be excused?
You may.
Thank
Who's
you.
next?
Middle of page 10, Judge. Annex, may we have Carlos Moises Grajeda?
Afternoon, Judge.
Good afternoon, Ms. Pages. He not in custody?
One moment, Your Honor. He's not on our list, Your Honor. Let me double check.
Is he not in custody?
Grajeda Carlos Moises?
I believe he is, Judge.
Yes, he is, Judge. He just wasn't on our list. And we have to go get him, Judge.
Okay, if you'll go ahead and do that and we'll come back. I'm only asking because I don't see him. I'm clicking his case and I think there's been some issues with this booking. I don't know how to correct Odyssey because it's reflecting he's not in custody.
Yeah, Judge, there were issues with the booking number, and I don't know if the jail saw that. The booking number is listed on the docket.
Mm-hmm. I guess part of my concern is going to be ultimately, Ms. Pages, I'm not sure how all these systems work together, but the docket's not reflecting he's got any time. And so if we ever get to that question, we're going to have some issues. We'll come back to that one. Thank you, Annex. Who's next?
Bottom of page 9, Judge. Annex, may we have Barnes, Benjamin Barnes?
Your Honor, are you gonna need Mr. Grajeda? Do we need to go get him?
Yes, please.
Yes. Okay. Yes, Your Honor.
All righty.
In cause number 2022-0D02121, State of Texas versus Benjamin Mitchell Barnes. Announcement of council, please.
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Brian Kennedy on behalf of the defense, Your Honor. We're ready.
And Mr. Barnes is appearing from the jail annex. We're scheduled for a bond hearing. Mr. Kennedy, you may proceed.
Your Honor, I mean, this is a situation where there is a range of misdemeanors. There is one felony, which is a burglary, a HAB, that's currently got $100,000 cash or surety. His bond's 128,500. And the evidence in the burglary of habitation is fingerprints on a crowbar that was outside the house, and no goods were found in his possession, but I can't get him out because of the 128,000 total. He is doing the working up with county reentry services right now. The jail reentry, not to be confused with the family violence. He says he's been working with Vanessa on that. He also has been working with the GI Forum outreach for housing, healthcare, financial assistance. And he says that he will be seeking and continuing with drug counseling at that point. He is indigent and has no wherewithal. And if there's anything above a PR bond, he's going to stay in jail. There is 2 more pre-files working on him right now that we talked about this morning. And so, I mean, he could have a significant stay while he's waiting for this, where the only issue, the felony issue is a burglary of hab with minimal evidence.
Okay. Is that all, Mr. Kennedy?
That's all I have, Your Honor. I try to
Okay.
make it short and sweet.
Okay, Ms. Rago, go ahead.
Your Honor, the state's concerned he was placed on PR bond on 3/21/2022. PR bond was revoked on 5/17/2022 and was enhanced to monthly reporting. The defendant failed to report in June. What's currently pending, there's a burglary of a vehicle, which was 1/3/2022. He picked up this burglary of a hab 2/17/2022, burglary of a vehicle 4/6/2022, burglary of a coin operated machine, which is a misdemeanor on 6/21/2022, and then a fraud possession identify info less than 5 items on 7/31/2022. The state's concern is he's just picking up cases so close together, Your Honor.
Where is that case, the fraudulent use or possession of identified information? I don't see that one as being indicted yet. It's the most recent.
It hasn't, Your Honor. I sent a request on July the 20, or sorry, that was this case. I sent a request on Friday asking what the status of the P files were, and I haven't gotten a response, unfortunately, Your Honor.
Okay.
I'll send a follow-up email right now to see if we can get it indicted.
Bear with me 1 second. I just got kicked out of the the PSR system. Let's see. So going back to the Odyssey system, there's the PR violation. So he has the 100,000 because he has been revoked, I think, twice. And once they could have revoked him on the PR bond and they did not over at the magistrate. So, but for I think 2 of the offenses listed, they all seem to predate maybe the PR component, but we do have 2 that post date his being required to follow conditions of bond. So that does not bode well at all for your client. With that said, in terms of the burglary of habitation, well, do you have anything else, Ms. Rago?
No, Your Honor.
Let me go and here, the PSR just double that. Okay.
Benjamin, I'm going to advise you not to talk today.
So I'm just reviewing the criminal history that we have in the PSR system.
Your Honor, if you'd like, I can outline it for you. I have it written up.
I think I'm good. I think I'm good with what you said. And I just wanted to see where some of these fell. I see the burglary of vehicles is showing May 3rd, 2022. The coin operated July 31st, and that is also the fraudulent use. So I'm good with those, but let me just see, it's showing something here from West Virginia. I feel like we've had a lot of these West Virginia entries, and I'm not sure. Did your client ever live in West Virginia, Mr. Kennedy?
No, Your Honor. Not that I'm aware of.
Is he former military or is he in?
Former military, yes.
So are you seeing any of that, Ms. Rago?
Let me see.
In 2022, June 14, 2022, Benjamin Mitchell Barnes, larceny, non-military property, $500 or less, probation violation from 2019, theft, embezzlement from 2019, stolen property, 2019. I'm going backwards. I shouldn't be going backwards. Marijuana possession in 2018. Larceny again. If you'll just double check what you're, maybe, I don't know if yours is.
I don't see the larceny, Your Honor. I do see the 30 grams of marijuana.
Yeah, I'm showing offenses, date ranges of July 2018 through, yeah, there's some entry here for June 14, 2022, but I don't know if that's some type of duplicate of a previous offense.
And Your
So-
Honor, my rap sheet was from March, so it may not include everything.
Okay. All right. Mhm.
I was just gonna say, was that offense in June in or out of town?
It's hard, sometimes these entries, I feel like they reflect activity, although they may not be a new offense per se. And it's a duplicate offense from one back in 2018. That's the larceny, non-military property, $500. And that one may relate back to, where is it? Drugs. Let's see. Stolen property. No, maybe it doesn't. Shoplifting, embezzlement of U.S. property, theft of U.S. government property.
Because he was here.
Mhm,
He went in
Mhm.
West Virginia, that's for sure.
mhm. So, yeah, I'm not sure about that last one, but between 2018 and 2019, I see at least a probation. He had a probation violation and the disposition was he was sentenced to 46 days. So not a lot of compliance there with any conditions. Initially, my thought was to reduce the bond, but no, I'm going to leave it the same. The request for a bond reduction at this time is denied. We're going to come back on Mr. Barnes' case. Oh, we're not coming back until the status conference in November. Let's go ahead and add another status conference for October, Ms. Hernandez. We're going to do October, we can do October 13th. And I want to check on the status of that fraudulent use case and see if we have that indicted by that time, see what the holdup is, because that's the only thing I think we have left outstanding. But that'll be the order of the court at this time.
Thank you, Your Honor.
Thank you, Mr. Kennedy. Who's next, Mr. Marufo?
That's all I have. Can I be excused?
Absolutely. Take care.
Top of page 10, Judge. Downtown, may we have Mr. Duron? In cause number 2020-0D00195, State of Texas versus Juan Carlos Duron. Announcement of council, please.
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Good afternoon, Brent Stevens on behalf of Mr. Duron, and we are ready, Your Honor.
Okay, and Mr. Duron is appearing from the downtown jail. We are scheduled for a bond hearing today. He's at a no bond, Mr. Stevens?
I believe so, Judge. It's a bench warrant.
Okay. All right, you may proceed on your bond request.
Judge, Mr. Duron was arrested on a bench warrant. He's on probation in this court. It is deferred from August 17, 2021. It's manufactured delivery, penalty group 1, 4 to 200. The affidavit for the bench warrant indicated that Mr. Giron admitted to his community supervision officer that he had smoked marijuana. So that was what was listed in the affidavit. And there, in speaking to him, there may have been some previous UAs for marijuana, but I do not have that information. So it sounds like that could be an issue in his life. He's 25. He's a U.S. citizen. He's been in El Paso his entire life. He has an address to live at with his grandparents if he's released. He was working at Carl's Jr., could probably get another job doing something similar. He has a GED. He has 2 children, and he pays child support. Part of the reason I think that the marijuana is being used is because there are mental health issues, and he's telling me about a couple of issues in particular that he has problems with. And so I'm requesting that he be linked with Takumi and OSAR but actually, you know what, TAP probably would take care of the OSAR part, but he definitely needs to be linked with Takumi if released. So we're asking for a PR bond so he could start reporting again and hopefully have clean UAs. He does have a trial set in October on a misdemeanor. I got this case probably last week, and the trial is set, I think, at the end of October. So we're going to get ready for that. I'm planning to be ready at that time, so that should be resolved one way or the other. That's all I have for today, Judge, unless you want to hear from I do not know if the CSO is here.
I'm looking at the report. I can tell you that initially they only requested an admonishment. It was my decision to request the bench warrant on Mr. Duron because of continued, although I think he was forthcoming in reporting it, as you mentioned, to his probation officer, then he failed to appear for one of the tests. And this has been an ongoing problem. And so what's the cause? Do you know the cause number on the misdemeanor, Mr. Stevens?
Yes, Your Honor. It is 2022 0D0. Oh no, wait a second. That's the wrong one.
That's my case. I'm looking at a misdemeanor and it's dismissed. That's the 2021 misdemeanor.
Well, you know what? Let me find it.
I have it, Mr. Stevens, if you need it.
Yeah, please.
2021 0C0 2721. The offense date is January 12th, 2020.
I don't know why it's not showing up on Odyssey right now.
It's not. And that's where I was confused. When I went into the misdemeanor, it did show a, I thought I saw a P file here somewhere, 2020 P file 13219.
I have an update on that. It was dismissed.
Yeah, that one was a DWI that was dismissed. What was the reason for the dismissal there?
Let me.
19 and 22, I don't remember reasons.
You're assuming I do. I
used to
no
know those
guarantees.
by memory, and I don't anymore. Plus, I don't know if they changed. So, in any event, Ms. Pineda, do we have any kind of update? I mean, I just continue to see, where is it? Admonishment, he tested positive, but I don't see a recommendation. No progress, community service, drug offender, completed at 8/19/22?
The drug offender education class.
Okay. And then TAP 314, progress, IOP and MRT.
Judge, if I may, as far as TAP goes, due to the last couple of times that he's tested positive, he has been upgraded to attend the moral recognition therapy, which is like an intensive part of TAP. And he did serve back, back in March, he did serve a 10-day jail commitment. Right now, he's been in custody, I believe approximately 10 days, Judge.
Mhm.
And yes, probation officer's recommendation is for this to be an admonishment for Mr. Duran.
Okay, I think I'm more, I mean, I'm not sure if there's a lack of understanding on your part, Mr. Duran, about what you need to be doing. Your attorney has suggested some additional resources, and probation has now worked on some additional resources. In other words, Carla, we don't have another screening or anything like that to identify what his needs are. Is that right?
Not to my knowledge, Judge. It's being just the MRT program.
Okay. Mr. Stevens, you mentioned Takumi. Should there just be some type of mental health screen for probation at this time? Okay.
I think that would be good.
Well, look, this is where I'm headed with this. So you may, and I know we're on a bond, so we'll look at that if we need to again. But my thought is, we've been through one jail commitment. I'm going to give him another jail commitment. And I will give him credit for the time that he was booked in on this bench warrant. And then we will modify him. I don't know if we need to modify in terms of the substance use, but it sounds like at least with respect to the mental health angle, we'll modify and get him screened there. And I don't know if we have anything pending, but I'm going to give him a jail commitment and then go from there. And now we can just do the bond. I don't have a problem going on that as well. We don't have any other cases outstanding other than the trial that you mentioned, which you'll be handling in the misdemeanor court. So that's where I am on Mr. Duran.
Judge, can I ask you how long your jail commitment is you're thinking about?
Sure. We were at, I was at 10 before, so I'll go to 20 now. Again, with credit for the time that he has in. When he comes out, he has to be compliant with all of the conditions, testing as we were doing in the past. And I mean, now is your time, in my opinion, now would be your client's opportunity to get on track.
Judge, can I convince you to do 14 days instead of 20?
No.
Well, I thought I would ask. Oh,
Of course.
I did speak to Mr. Duran, and to me, he sounds like he does want to succeed and he does want to take care of his kids. I think he just, once he can get the marijuana out of his life, he'll be fine.
Yeah, he just needs to follow his probation. If it's a real problem and he's going to be utilizing resources, I think, Mr. Stevens, you're the first to remind the court, how we don't always have perfect performance, but what I'm not seeing is enough of a compliance at this point. So happy to provide the tools. I want Mr. Duran to be successful, but there is going to be a sanction for his conduct, and that's those 20 days. So we can modify him accordingly, get him that OCJ credit, whatever we need to do to get him to do those 20 days, get those completed. Mr. Duran, if I hear your name again, or I see your name in an email again from probation, where you are right now might be where you stay. Okay?
Thank you, Your Honor.
Mr. Stevens, we don't have, oh gosh, now I got out of that case. And I don't think I can get back because it's not linked. A ver. Mr. Duran. We'll do a review, probation review hearing in 60 days. That should get us past your trial and whatever happens there, and we'll see what happens with his performance.
Hey, thank you, Judge. And Mr. Duran, when you get out, can you please call me at the public defender's office, and that way we can prepare for your trial, and I can also keep you informed about the Zoom settings for this court.
Okay, sounds good.
All right, Thank you, Mr. Stevens. All right, anyone else downtown?
That's the only one they had, Judge.
Thank you. Who's next?
Mr. Stevens also has Villegas, bottom of page 10, Judge.
Who is this Garza? Who is our interpreter here for?
Oh, for Mr. Grajeda. Annex, did we get Grajeda?
Thank you, Judge.
Yes, Ms. Garza.
He'll be right out, Your Honor.
Okay, if we can get that function going and then get started.
Sí, claro que sí.
Yes, ma'am. Okay, wonderful. Go ahead.
In cause number 2022-0D03575, State of Texas versus Carlos Moises Grajeda. Announcement of council, please.
Samantha Raga on behalf of the state treasurer, Your Honor.
And Mirna Pages for Mr. Carlos Grajeda, ready as well, Judge.
And Mr. Grajeda is appearing remotely from the jail annex. He is also utilizing the assistance of a court interpreter, Ms. Lynette Garza. We are scheduled today for a bond hearing. Ms. Pages, you may proceed.
Judge, just so for the record, Mr. Grajeda went before the JMAG judge last week, Judge Muniz, and he was granted a PR bond. I'm a little confused.
Well, let me unconfuse you and also for your client's benefit. So the case when it was set in the jail magistrate court, the jail magistrate did not realize the case was already indicted and assigned in this court. And the jail magistrate did not have authority to hear any matters with respect to your client's bond. And yes, thank you for reminding me because I did want your client to understand, because my understanding was they contacted me when they realized it. So I'm not sure what time that hearing was. I feel like it was in the morning, but I didn't hear of it until very late in the day, I think on Friday or Thursday. I don't remember which day it was. But when I was told that they had made that mistake, of course, that they should not have had that hearing. And so we had that vacated, that order vacated, and had your client set at the first jail setting. So that's today. So Mr. Grajeda, so you understand that was the procedural angle on why that hearing, you were not released on that PR bond. So now you're before the judge that actually has your case. That is the issue. And so Ms. Pages, you may proceed.
Yes, Judge. So I guess if Mr. Grajeda can be given the benefit of the doubt, since I believe because of what happened and the confusion that occurred, he's the one that is harmed at this point. My client, Judge, had originally been given a PR bond through JMAG, I believe August 11th of 2022. While out on PR bond, picked up a new offense, a criminal mischief case, Judge. I believe this occurred August 18th of 2022. And I hope I'm not speaking too fast. Okay, and Judge, so what I had indicated to Judge Muniz at the time is that my client, Mr. Grajeda, had made me aware, and I spoke with him that very same day as when I first met with him, because this case was just assigned to me. And I spoke with him over the phone, and he had indicated to me that when he had been released, he was not on his medications, and because he does suffer from schizophrenia, Judge, he does have hallucinations. In particular, he hears voices. And so at the time, the voices were telling him not to take his medication. And so he just ended up in a really bad spot. And he did, in fact, commit a criminal mischief. So he did plead guilty to that, Judge. He pled guilty, I believe, September 1st of 2022. He was sentenced to 20 days at the El Paso County Detention Facility. So he was aware that it was a violation of his PR bond. He took responsibility, Judge. He did plead guilty. My client, Judge, when I met him, he indicated that at the time he was living at the OC at 1208 Myrtle, which is the Opportunity Center. He attended Isleta High School. He obtained a GED from Colorado. He also, at one point before his mental health issues, was actually going to Western Tech and was taking advanced welding. Now, because of his mental situation, he is actively trying to obtain disability. Aside from schizophrenia, he does suffer from bipolar. He also has insomnia, paranoia, and hallucinations as well. He has been linked with EHN, Judge. He is currently on medication. He is a U.S. citizen. He is 36 years old. He intends to continue taking his medication, Judge. In fact, he assured Judge Nunez last week that he would. And so at this point, Judge, we are asking for him to be granted a PR bond. I don't believe it is his fault with respect to what occurred last week. I don't know. I'm not in charge of scheduling matters, that is for certain, but I do know that he was harmed in the sense that he was under the impression that he was able to get out of jail. And until recently, I discovered that he had been sitting in jail all this time. He was never, in fact, released from jail. I was told at JMAC, Judge, that he is to be indicted on another felony case, but it's not anything that he picked up while on PR bond. I believe it's something that the DA's office had not gone around to indicting it. So I think that's also where some of this confusion might arise, is that there's actually 2 felonies. And I was told that that should have been or would be going before the grand jury this week. So based on the foregoing, Judge, we are asking for a PR bond. We are asking for this court to give Mr. Grajeda the opportunity to prove to this court that he can comply. Asking you, Judge, to take into consideration his mental health. He's not like anybody that does not suffer from mental health. He has significant mental health, Judge. He is on medication. And so we are asking for him to be given this opportunity. Judge, thank you so much.
Okay. And so oh gosh, what was I going to ask? Oh, before we get started, Ms. Rago, on your argument, what is the date of, I did see the burglary of building on the jailing. And so what's the date of offense? I kind of assumed they were out of the same incident.
It's showing 8/5/2022. The robbery is 8/4/2022. Ms. Pages is correct. On the burglary of a building, it was accepted and grand jury was actually today. So hopefully it'll get assigned to this court within maybe the next 10 days. My understanding is the county has 10 days to assign a cause number.
Mm-hmm. Is it, do we know, I don't know what you can see, Ms. Rago, are we talking about same victims in each of those cases? Since they're kind of a day, it looks like there's a day apart. Or are these separate incidents?
Let me see. So my understanding, the burglary of a building was with Family Dollar. This specific case was at Circle K.
Okay, so we have 2 victims. Okay. All right. Now, okay, Ms. Rago, go ahead.
The state is concerned. There is some criminal history. There was a 2005 possession of marijuana between 5 pounds and 50 pounds. He was placed on deferred and then was revoked. Then there was an unauthorized absence of community correction, which was a state jail. And I believe it was reduced down to a misdemeanor because he only served 18 days. There was also out of state, there was an assault from Denver, which was unknown for the disposition in 2004, a DWI that was dismissed, a DWI that was a conviction in 2015 out of Adams County. In addition, there was an assault felony menacing with a weapon out of 2016, unknown punishment, and then there was about a parole violation in 2020. It didn't say what it was, so I'm assuming it was that that assault. And that's the extent of the criminal history, Your Honor.
Okay, so I'm seeing, okay, so he's done, he's had a pen trip in Texas, at least one, right?
Yes, Your Honor.
And then I am seeing history in Colorado and in Arizona as well. In Colorado dating back to 2004. Let's see, how many events? 8. Keep going. 15 events all the way up until 2022 in Colorado, to include a parole violation and several violent offenses, escape, failures to appear, assault, strangulation, assault. That's Colorado. And if we go to Arizona, starting in 2010, criminal damage, DWI, extreme DWI, failure to notify the state. No, failure to notify striking fixture, criminal damage. These are going through 2020. So there's one strange. These are kind of not divided the same way. These all, it looks like it's Tucson. More DUIs. Yeah, we have an extensive history, criminal history and non-compliance with any type of conditions here. And I understand the extent to which, you know, the mental health component can be a factor. So I am considering that. His bond is $35,000. Ms. Pages, your office is usually really, really good about putting together some type of plan if he's, if you know, a client is to be released. Do we have anything like that in place here? I don't recall if I heard where he would be living, what kind of ties to the community, things like that.
Yes, Judge. So there is a plan in place, Judge, which is the following. He is going to be residing at the Opportunity Center located at 1208 Myrtle. Client should be released basically between 8 a.m. and 4 p.m. directly to that center. He's also to follow up with Emergence Healthcare Network to address any mental health needs, and specifically he has been linked to Takumi. Client is also advised to follow up with the Social Security office to help him obtain his disability, which he's been trying to do. However, his mental health does get in the way. So those are the services, and that is where he would be residing, Judge. And he is indigent, he has no money, so he cannot afford anything. And Your Honor, just for the record, this bond is just for cause number ending in 3575, is that correct?
That's the only one I have, if I'm not mistaken. Let me see. 3575. Yeah. No, I think the third, he was on PR on the others already. On which ones, Ms. Nieto? Are you talking about the burglary of building, or what are you talking about?
Yes, ma'am. Those bonds were not vacated. It was only the indicted case. So it has already been released on the.
Ms. Nieto, if you're talking and you're not on the English channel, I can't hear you.
Sorry, Your Honor, I forgot. Yes, he was already released on the burglary of building. It was only the indicted case.
Okay.
That he's being held on.
Okay, thank you. Okay. Yeah, no. I'm not at a reduction in the bond at this time. The bond request is denied.
Thank you, Your Honor.
Thank you very much. All right. Anyone else need an interpreter? Ms. Garza, if you'll let him know that his hearing has ended and he can reach out to his attorney, please.
Okay, gracias.
Thank you, Ms. Garza. I want to say no, but I can't, I'm not sure when I'm on the English channel if I'm hearing everybody. So does anyone else need the interpreter?
I don't believe so, Judge.
Thank you, Ms. Garza. Have a good day. Who's next?
On page 11, Judge,
Go ahead.
annex, may we have Josh Warner?
Oh, this is the arraignment. Did we make sure Mr. Warner would have a copy of the indictment? Ms. Pages, did you provide that to him or?
And no, Judge, so this is a case where I've gone to the annex and I have not been able to see him. He's refused his attorney visits.
Okay, I thought the request today was to have Mr. Warner arraigned.
Yes.
And so, Mr. Warner, you need to be able to have, he needs to have a copy of the indictment.
Okay.
Would you like me to email to the annex court? Maybe they can print it?
If you could, I don't know if Annex, if you can do that, we need to make sure he has a copy of the indictment.
And there's two causes, Judge.
Yes, Your Honor.
Judge,
Thank you. Mhm.
the actual arraignment package went directly to the public defender with a copy of the indictment.
Yeah, I think when I received the email about this request, I included in my response that the defendant would have to have available to him the copy of the indictment. So let's see. Yeah, just need to make sure the defendant has a copy of the indictment. Mr. Warner, have you seen the indictment in your cases?
I have not.
Okay.
I've been sick.
Judge, are we able to orally just read the indictments? They're not very long.
No, I want to make sure that he sees a copy of it, knowing at least at this point that we might have some confusion. I don't want any confusion. To be honest, I agreed to have this continue remotely only because of the quicker turnaround. But my inclination is to bring him in person, to bring
Yes,
Mr. Warner in person. And so, Mr. Warner, that what they're going to do, is that your request, Ms. Pages?
Yes, Judge, I think that would be better just to have them transported and.
I agree. I agree. And I should have gone with my first instinct. I just didn't want to have any delay. How quickly, Mr. Marufo, can we put in and can the jail manage a request to have him transported tomorrow morning? Can they turn it around that quickly?
I believe so, Judge. Let me call real quick.
Okay. Mr. Warner, because the arraignment, yes, I see you have, and so that's great. Those should be, without me being able to see them, those should be the two documents that charge you officially in each of these cases. Okay. And so the first step when you appear in court is an arraignment. It's a process by which you enter a plea of guilty or not guilty. Okay. That process, rather than accomplish it remotely as we're doing over video conference, I am going to order that you be transported here to the court so that you can see those directly and I can communicate with you directly on the arraignment. Your attorney, of course, will be present as well. We'll all be in person. So I'm just making arrangements now to see if the jail can transport you tomorrow morning, okay?
Okay. You
Okay.
can't do it today?
I am of the opinion that when we do these arraignments formally, we should do them in person. Is there any impediment to you appearing? Do you have any illnesses or anything like that
I've been sick. That's why I haven't been able to see my attorney. It's been like difficult for me to move and get out of bed. I'm on observation too.
Okay.
That's why it would be better if we were able to do it today, because it was hard for me to move because I'm not super sick.
Okay, so I just want to make sure the document that you're looking at, Ms. Pages, are you okay with that?
I am, Judge. If I can just instruct my client, Mr. Warner, if you can just enter pleas of not guilty for each of the cases. Do you understand?
Yes.
Okay, so Mr. Warner, I am going to ask just for my own peace of mind, those two documents, can you kind of turn them around so I can see what they are more or less? Okay. Alrighty. Thank you, Mr. Warner.
Okay.
Judge, downtown said, yes, they could have him here tomorrow.
Okay, let me just, I want to make sure I'm seeing the document as well. Hold on. Okay. And let me just make sure I ask this question correctly for my purposes. Ms. Pages, do you have any objection at this point in doing the arraignment remotely?
I do not, Judge. I think it is based on the statements of my client that it is in his best interest based on his health at the moment.
And this one. Okay. All right, let's go ahead and get started. And I'll actually kind of just call these separately so there's no confusion. Mr. Warner, we're going to start with the document that should have handwritten on top of it a cause number 2022 0D03084. Do you see that one?
Yeah.
Okay, so calling cause number 2022 0D03084, State of Texas versus Joshua Warner. May I have announcements, please?
Samantha Rogg on behalf of the state. State's ready, Your Honor.
And Meredith Pages on behalf of Mr. Joshua Warner, ready as well.
And Ms. Pages, do you recognize your client appearing from the jail annex?
Yes, Judge.
Okay, Mr. Warner, we are scheduled for an arraignment today. Your attorney has requested that we do a formal arraignment rather than have a waiver signed. And so the court, off the record, the court clerk provided you with two documents. In this case, there is a document there that you were holding. Do you recognize that as having the cause number on that document?
Yes, Your Honor.
Okay, so we can get started. I'm going to be asking you a few questions. Your formal arraignment is your opportunity to enter a plea of guilty or not guilty, but I need to swear you in, okay? Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Would you state your name and date of birth?
Joshua Warner, 05/15/1998.
Mr. Warner, as I mentioned, you have a document in your hand, the indictment in this cause. It is the charging instrument. In this case, it's charging instrument for possession of a controlled substance in penalty group 1 or 1B in an amount less than 1 gram. That offense is a state jail felony, sir. That is punishable from anywhere between 6 months to 2 years confinement in the state jail facility and or a $10,000 fine. Do you see your name on that indictment, Mr. Warner?
Yes.
Is your name spelled correctly?
Yes.
To that charge, sir, how do you plead at this time?
Not guilty.
And do you waive reading of the indictment?
Yes.
Okay, then I will go ahead and enter your plea of not guilty, as I mentioned to you off the record. And I'm sure your attorney has explained to you that is just the formality of the beginning of your cases. So now we're going to go to the second case unless someone has any questions regarding cause number ending 3084.
No questions, Judge.
Okay, so we're adjourned on that case. Now calling cause number 2022 0D03085. Mr. Warner, I'll ask you to look at the documents that you have and see if there is an indictment there under that cause number.
Yes, Your Honor.
Okay, so let's do this one more time. I'm going to ask you questions, so I need to swear you in. Would you raise your right hand? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Okay, you can put your hand down, and again, one more time, your name and date of birth.
Joshua Warner, 05/15/1998.
Let me make sure I pull that one up. Okay. Sure. Looking at the indictment under this cause number, it is an indictment for aggravated robbery. That is a first-degree felony. It is a first-degree felony, which is punishable anywhere between 5 and 99 years or life in the state, in the Texas Department of Criminal Justice Institutional Division, and/or a fine of $10,000. Do you see your name on that indictment?
Yes, Your Honor.
And is your name spelled correctly?
Yes.
To the charge of aggravated robbery, sir, what is your plea, guilty or not guilty?
Not guilty.
And do you waive reading of the indictment at this time?
Yes.
Okay, so the defendant's plea will be entered in this case as well. I do see now with respect to each of these cases that we do not have another court setting until November 8th. So I expect that you'll be in contact with your attorney on these cases, Mr. Warner. Ms. Pages, if you need any hearings in the interim, because it's a little bit of time, maybe more than a month, that you will file anything you need to be heard and request your hearing accordingly, okay?
Thank you so much, Judge. I do appreciate that.
Absolutely. Mr. Warner, you'll be in touch with your attorney, okay? We'll see you at the next setting.
Okay.
All right, we're adjourned. Who's next? Thank you, Ms. Pages.
Bottom of
Judge.
page 10, Judge.
Monday.
Bottom of page 10, annex, but we have Villegas, Abraham Villegas.
Excuse me, Your Honor, who do you need next?
Villegas.
Yes, all right, she's coming right up.
Thank you. Mr. Stevens, his bond is $5,000, is that right? Or am I looking at something?
That is correct, Judge. 5,000 cash or surety.
Thank you.
Yeah. Right.
All right, is that Mr. Villegas?
Yes, Your Honor.
Okay, go ahead.
In cause number 2022 0D03743, State of Texas versus Abraham William Villegas. Announcement of council, please.
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Brent Stevens for Mr. Villegas, and we're ready, Your Honor.
Okay, Mr. Villegas is appearing from the jail annex remotely. We're scheduled for a bond hearing. I think his bond is $5,000 cash surety. Mr. Stevens, you may proceed.
Yes, Your Honor, Mr. Villegas is being held on a theft charge. It's $2,500 to $30,000. He is a U.S. citizen born in Hobbs, New Mexico, but he's lived in El Paso since about the age of 13. He has an address in El Paso, if released, to live with his wife and kids. He has 5 children. Mr. Villegas is self-employed. He has a GED. He also has an associate's degree from 2012. He has been to prison once before, and I believe that was for drugs. There are mental health issues, and we are requesting that he be connected with Takumi as a condition of a PR bond. His wife has called me multiple times. So I know she's very interested in his release, and he has indicated to me that he does want to be on medication for his mental health issues, but he's not receiving that currently at the jail. So that's where we're at. Basically, this is an accusation of the report indicated that an employer was accusing him of stealing tools, and they say they have a video, although there's not a video on Odyssey. The story is a little bit different. As you know, there are 2 sides to every story, so we'll go into that later, but we are asking for a PR bond.
Okay, Ms. Rago?
As Mr. Stevens indicated, the defendant does have some criminal history. There was a tampering with evidence, which is a 2019. This was run concurrent with the possession of a controlled substance, PG1. Mandel, 1 to 4 grams. Those were run concurrent, and then he was also revoked on the possession of the controlled substance, PG1. That was in 2018. He was revoked to 6 months state jail. In addition, there was possession of marijuana less than 2 ounces between 2010 and 2012. That was 3 different times. An AFE, and it was reduced down to a misdemeanor in 2010. In addition, there was criminal mischief, which was a misdemeanor probation, where he was revoked to 6 months. And that, according to the rap sheet, there's nothing outside of El Paso.
So I'm a little worried, Mr. Stevens. The only thing that kind of brings me a concern is if we're talking about, I don't know the extent of the mental health issues, but that he's not receiving any treatment. And I'm guessing he needs you're asking for a straight PR bond, right?
Based on my conversations with Mr. Villegas and his wife, I do not think they can afford anything more than maybe $100 or maybe $200.
Mm-hmm.
So maybe a small surety portion, but not very much. I mean, he's being held on a $5,000 bond, so they don't have very much money.
Okay. I'm sorry, Ms. Rago, what's your position on the bond?
We'll defer the court, Your Honor.
Okay. So, and I guess the CW is a former employer, or, I mean, we're not going to have any contact anymore, Mr. Stevens?
No, we can have no contact with the complaining witness. I do not have the complaining witness's name or information currently. Mr. Rago could provide that.
So I'm going to go ahead and grant the request for a full PR bond. It'll be a $5,000 PR bond, but he will have that Takumi referral. So I don't know. Let me see. Let's see. You're following all treatment plans that are prescribed, or any other appointments with Takumi. You must attend those. I'm going to have him reporting. I'm I'm gonna have him reporting weekly for now, Mr. Stevens, just until, I'll assume you'll come back to me if that becomes too onerous and he's on track with any kind of mental health unit. Report weekly, you may not have any contact with the complaining witness and you must stay 200 yards away. I don't know, is there a place of business or is this not a place of business? Like, is there a location or are they doing work kind of just out of a van and a truck, that kind of thing?
I think it's just out of a family truck.
So no contact with the complainant or the business. So, if it's not just the complainant, if it's workers that are part of the complainant's business, no harassing, no bugging any of those employees. Subject to testing, you're to drink no alcohol or use any illegal substances. I got to think that there's with a mental health concern, those can't be good things. Commit no new offenses, maintain current contact information, may not change place of residence or leave El Paso County without court permission. Like I said on the frequency, Mr. Stevens, if I think they're still reporting by phone, is that right? Or are they reporting in person?
I believe by phone, Judge, but I was just gonna bring that up because I'm sure that's gonna be changing. Can you make it reporting by phone?
I will make it reporting by phone, irrespective of whether, the protocol goes back to in-person reporting, because I think for me, I just don't want to lose track of Mr. Villegas. So a weekly phone call to me does not seem to be much of an inconvenience. Any other conditions, Ms. Rago, that you feel need to be added?
Did you address curfew, Your Honor?
Oh yeah, we'll do a curfew. Well, Mr. Stevens doesn't like. We'll do a curfew, but it won't be a crazy one. We'll do 10 p.m. to 5 a.m. That should give him time to do whatever work he needs to do. Okay.
Yes, thank you, Judge. Mr. Villegas, when you get out, can you please call me at the public defender's office right away? And then I can give you the information about where to go for Takumi, okay?
I sure will.
Okay,
Yes,
thank
sir.
Don't lose contact with your attorney. As soon as we find out you're not reporting or he's having trouble contacting you, that's going to be a huge red flag for me, Mr. Villegas. Okay?
Yes, ma'am.
Oh, great.
you.
Thank you very much. Anyone
Thank
else?
That's it, Judge. Juan Navarro was reset.
Okay, so who did I have public defenders on that I wanted them to meet? Is it Mr. Garza?
It's Garza, Judge.
Okay, thank you. So I'm going to go ahead and log off, Ms. Rago. I don't know if you log off too.
I'll log off.
But if not, we can also put them in a breakout room.
Bye, Judge. Have a good day.
Mr. Maruco, did you say Juan Navarro was reset?
Yes.
Thank you.
Right now, was somebody from the public defenders gonna log in? So for Garza?
I sent him the form, Joe, but I don't know if Myrna was on.
She logged out.
I'll send her an email.
What's your name?
Bueno,
Navarro, your attorney rescheduled your hearing for today, okay?
okay.
All right.
Okay.
He said he'll go visit you when he gets back.
Okay.
Thank you.
Thank you.
Mr. Marruco, that's the last defendant we had at the annex.
Yes, we're trying to get the public defender's office back in so they can talk to Alfredo Garza.
To who, I'm sorry?
To Alfredo Garza.
Garza was already sent back to his cell. Are we gonna need him?
You told me.
The judge wanted him to talk to public defender.
Why don't we check the other end first, yeah?
Yeah.
They cut off the YouTube channel.